Sigma presents Business to Government. With MEP Peter Agius.
Well, the situation with the gaming market is that since the Commission has decided to take a step back and not act on cases which seem to be that the member states are limiting the market to outside operators, to operators coming from other member states, since the Commission has decided to wash its hands and not regulate, not take infringement proceedings against member states who seem to be adopting protective measures which are against the treaty, what happened is that we have a bit of a jungle building with different member states having their own laws and their own regimes and their own licensing systems. This led to a situation whereby you had also the extremity of cases whereby uh, losing bidders, okay, in certain member states had the temerity of suing in court the operators of gambling services for the losses they made on the presumption, on the argument that that operation was against the law in that specific country. Now, what led to Bill 55 is that Malta tried to assert its right to be a base for these gaming companies and tried to protect its local operators from these losing bidders court cases. The question, of course, put into the spotlight the Maltese authorities' action because it no longer remained a question of online gaming, but it became a question of recognition of judgments. So, whereas the Commission has declared that it's going to abstain from taking action or taking any regulatory or implementative action on gaming whatsoever. This is what the Commission has declared, black on white. But the moment that Malta tried to regulate whether a judgment, let's say delivered in Austria or Germany, can be executed, can be enforced in Malta, we left the realm of gaming and entered into the realm of recognition of judgments, which is much wider, much wider. And the whole castle of the European Union and our laws, which need to be recognized, and our authorities, which need to be recognized reciprocally in the different member states, rests on this recognition of judgments. So a judgment is delivered in France, you can assume that you can use it in Malta. This is the law. This is there's a whole series of legislation that. So the Commission had a very strong case against Malta with regard to Bill 55. If you take it in general terms on whether one member state can block the enforcement of a judgment in another member state. If you take it just a general question, it is definitely a strong case against Malta. It becomes a less evident case when you consider that this is gaming. So when you consider that we're speaking here of a sector whereby the Commission has failed to do its duty as guardian of the treaties. And this is why when I reacted publicly to the announcement of the European Commission through Commissioner McGrath that the Commission is taking action against Malta by issuing a letter of formal notice. What is a letter of formal notice? Basically telling Malta, listen, you need to change this, otherwise I'm going to take you to court, right? My reaction to that publicly was I'm urging the Maltese government to come in line with EU law, but at the same time, I'm attracting the attention of the European Commission that if we're going to act on gaming, we need to act on both sides of the problem, because there are both sides of this. And the other side on which I'm calling the European Commission to act upon is the regulation of these third-party litigation funding, which is leading to these court cases in Austria and in Germany, basically, then in a very morally doubtful way, you know, having these losing gaming operators basically presuming that they can take back all their losses simply because in one jurisdiction this gaming service was considered to be operating beyond the boundaries of the law. No, I don't think that there is much of an issue about that, because what we're seeing is that these issues are very much concerned with gaming. So we have also a few cases of, for instance, member states and operators not notifying actions which are in theory requiring a notification to the European Commission because they are limiting the market, or they are, for instance, establishing monopolies. There is a specific notification regime for that. And the Commission is basically not acting upon these infringements. But what we're saying is this is normally restricted to gaming. So I don't see the court, an eventual court action or an administrative action by the European Commission. Of course, it is under the chapeau of recognition of judgments, which the Commission is defending as its territory. But I don't see implications beyond gaming at this stage. Maybe something will happen in the future to change this, but at this stage, this is something which concerns gaming. Yes, I know that there is a lot of interest to this question. There is a lot of silent observers seeing what's going to happen next. I do not know. I will not speak for the Maltese government directly. I mean, the Maltese government, to my mind, to my knowledge, has not reacted officially to the letter of formal notice, but unofficially, I mean, behind the scenes, the Maltese government now has the right to reply to this letter of formal notice, maybe even contesting the Commission's decision to request, to request a change in the government's action with regard to Bill 55. So there we need to wait to see how the government will reply. And unfortunately, the government's reply will not be public. So normally, this exchange of letters between the Commission and the Maltese government are not published in detail. What we have is a statement by the Commission saying that there will be a letter of formal notice. The statement in itself gives basically the ground, but does not go into the detail. And then the formal letters themselves are not published. They are between the Commission and the Maltese government. So after that, we will know if this question has been solved or not, because the next step would be the Commission would announce either that this action has terminated, that it is satisfied with the reaction of the Maltese government, or that it will be taking further action, which may include court action in the European Court in Luxembourg. I think I cannot blame the Maltese government and the Maltese Malta-based operators that they feel the need to stand up to these court judgments whereby they are found in in breach of a law which in itself is, by all the looks of it, um, not respecting a European principle of free movement. Okay, so this is a very strange situation where we are expecting operators in Malta to pay up for the losses, okay, for the losses incurred by gaming operators, which, if you see, the regime in Malta has very high player protection mechanisms. very good measures for player integrity and game integrity, okay, and a very clear licensing regime operated under the Malta Gaming Authority. So morally, I find it very hard to accept, okay, these judgments, which are simply based on a technicality that you have a court which is sympathetic to your case because it wants to protect its jurisdiction. Okay, this is what it is. Okay, I'm speaking very frankly here. Um, so I do understand there is a rationale of the Maltese government, and I believe that the Maltese government was essentially responding to the needs of the industry based in Malta. If you ask me what is the step forward, I believe that the situation at present is not very sustainable. I believe that the Commission's decision to basically take a step back, wash its hands completely, and not regulate at all, and not even consider any breach, any infringement proceedings against any member states, because it's gaming and leaving gaming as the law of the jungle, I think that is very unsustainable. I have said so in official letters sent to Commissioner Sejourné and Commissioner Migrat, and I insist on this. Now, it's not easy to solve the situation because the situation with the fragmentation of the market has reached now its a very serious state. So it's not easy to regulate now. It's not easy to solve the matter. But I think we must fall back to the European Court of Justice and its recognition of freedom of movement and proportionality in the sector. So let us always remind ourselves that gaming is still subject to the treaty, and that the treaty says that although member states can take measures to limit free movement in case of a question of public security or public order or public morality. Okay, this is the article that member states use to limit the operation of online gaming. But even that has to be proportionate, and that is not exceeding the measures needed to actually satisfy that public need. Okay, and what we're seeing is really putting into doubt whether this is proportionate, whether this is a question of responding to public need, or maybe going beyond and limiting markets just for the sake of protecting your own industry and your own national interests. So maybe a return to proportionality, a return to free movement is really the only way forward. And I will be doing my bit for sure in different ways, in different forums, in different formats, different occasions, to make sure that we build our case, that we are not giving up on the free movement in the area of gaming. At the same time, of course, I plead on the industry in Malta to hold strong, to keep innovating, to keep being at the forefront of player integrity, player protection, the protection, all the measures against securing against minor involvement. So we need to keep having the high moral ground in the sense of having a very serious regime, complying to the license requirements, complying to all the national laws which have made the gaming industry in Malta having a very good reputation overall and becoming a point of attraction, a point of reference globally. Yeah, as things stand right now, I don't see the political will, because I cannot speak for Peter Agius alone or the Maltese MEPs, or I cannot even speak for the European People's Party, or maybe MEPs coming from smaller member states. I cannot really do that. But what I see around us is that there is no political will. There is no clear consensus on how to regulate gaming, because there might be some of us who would want to see more free movement, but there would be some of us who would want maybe an abolition of gaming, or maybe significant restrictions. So I don't see the climate as yet. It would be ideal, of course, if we have first of all the Commission acting on what are the fundamental freedoms already clear in the treaty. And then maybe there is room to regulate some aspects of gaming indirectly. So indirectly, not necessarily acting on gaming as an industry itself, but possibly indirectly speak about, for instance, the criteria for responsible advertising of gaming, or the criteria when it comes to responsible gaming and the limits to protection of minors, and the measures needed to prevent addiction. Of course, there are aspects which could be touched upon through other aspects of legislation. Let's say the Digital Services Act has some impacts on the gaming industry. The AI Act has some impacts on the gaming industry. So there are the GDPR, data protection, has definitely aspects of impacting the gaming industry. So it could be that we would seek aspects of harmonization which affect gaming, but as are not necessarily regulating gaming as a game of chance across the member states in itself.